Welcome back, dear students. Today we will learn what is a writ of certiorari. We have already studied that there are five kinds of writs available under Article 32 and Article 226. Supreme Court has power to issue any of these five writs under Article 32, whereas high courts in our country, they are empowered to issue any of the five writs under Article 226 of Constitution of India. And the abbreviation for five writs in the earlier lecture I told you is HMPQC. H for habeas corpus, M for mandamus, P for prohibition, Q for quo warranto, and C for certiorari. So today we are going to take up the writ of certiorari. First of all, we will try to understand the meaning of the word certiorari. Certiorari, dear students, is a curative writ when Supreme Court or High Court is of the opinion that a lower court or a tribunal has passed an order which is beyond their powers and they have committed an error of law, then through writ of certiorari, the High Court or Supreme Court, as the case may be, transfer the case to itself, ask the lower court to send the file to the High Court or Supreme Court, or to quash the order passed by the lower court or the tribunal. This writ of mandamus, meant for rare use, by which an appellate court decides to review a case at its discretion. The word certiorari comes from Latin language and it means to be more fully informed. A writ of certiorari orders a lower court to deliver its record in a case so that higher court may review it. So dear students, a writ of certiorari is issued by the Supreme Court or High Court to the subordinate courts or tribunals in the following circumstances. Or you can say these are the conditions when a writ of certiorari may be issued either by the High Court or by the Supreme Court. The first circumstance or first condition is number one, when a subordinate court acts without jurisdiction or by assuming a jurisdiction where it does not exist. So in both the cases, subordinate court is acting without jurisdiction, or if it is assuming jurisdiction which it does not possess, still the working is without jurisdiction. So this is the first circumstance. Second is when subordinate court acts in excess of its jurisdiction by way of overstepping or crossing the limits of jurisdiction. Excess of jurisdiction means, suppose you are posted in Gautam Buddha Nagar as civil judge junior division, and your powers of deciding the civil cases is fixed at 25,000 rupees. But you have decided a case whose valuation was 1 crore rupees. So that means that you have decided a case in excess of your jurisdiction. Once you exceed your jurisdiction of 25,000 rupees, that is a valuation fixed for the jurisdiction of civil judge junior division. The moment you overstep it, the moment you cross the limit of 25,000, a writ of certiorari can be issued against you because you are acting in excess of your jurisdiction. Third circumstance when certiorari can be issued is when a subordinate court acts in flagrant disregard of law or rules of procedure. You are hearing a case, you have decided a case in flagrant disregard of law or rules of procedure. Fourth circumstance when certiorari can be issued is when a subordinate court acts in violation of principle of natural justice. Where there is no procedure specified in law, you are not following the principle of natural justice. And natural justice demands that other party should be heard, like audi alter partem is the part of natural justice. You must be fair in hearing. You must hear the other party. You must be just in your action. All are parts of natural justice, and if you are not following the principles of natural justice, a writ of certiorari can be issued against you. Now, dear students, we'll see what are the features of a writ of certiorari. So, various features we will understand under the following heads. Feature number one is that certiorari is an order of superior court. Certiorari is always an order of the Supreme Court or High Court issued to the inferior courts, tribunals, or authorities. For what purpose? To transmit the record of the proceedings pending with them for scrutiny. You are hearing a case, but the High Court or Supreme Court has power under writ of certiorari to call for the record of pending file with you. And if necessary, your order may be quashed by the High Court or the Supreme Court. So feature number one is it is always an order of the Superior Court. And this writ of certiorari may be issued whenever any body of persons having legal authority to determine questions affecting the rights of the subjects and having the duty to act judicially act in excess of their legal authority. Whenever the presiding officer of a court or tribunal is acting in excess of their legal authority, the writ of certiorari can be issued against them. To illustrate it, I am referring to a leading case, Province of Bombay versus Kushal Das Advani. In this case, the house of Mr. Kushal Das was acquired under Land Acquisition Act, and the government was given power to acquire the land in following terms. This is the language of Land Acquisition Act, that if in the opinion of the provincial government it is necessary or expedient to do so, the provincial government may, by order in writing, requisition any land for public purpose. So land can be acquired for public purposes by the provincial government. It was held in this case that decision about the necessity of acquiring of land was left to the unfettered subjective opinion of the government, and there was no judicial process involved. It was an administrative act of the government. Hence, no writ of certiorari was issued against the government because none of the court, none of the lower court had passed any order. None of the tribunal had passed any order which needs quashing by the High Court or Supreme Court. So this case illustrates that the decision of the government to acquire the land and house of Mr. Kushal Das was an administrative act of the government. Why? Because no judicial process was involved, none of the court was involved, there was no lower court, so the writ of certiorari was not applicable, and no orders were passed against the government. So this leading case illustrates that it must be the order of superior court must be for correction or review or quashing of the order of the lower court, and in Kushal Das' case, none of the court was involved, hence writ of certiorari was not maintainable. Then another illustration. You will understand this illustration with great interest. Board of High School and Intermediate Education versus Chitra. In this case, a writ of certiorari, Supreme Court quashed the decision of the board who had cancelled the examination of a candidate on the ground of shortage of attendance. On the ground of shortage of attendance, the board cancelled the examination of Chitra. But after admission to examination, the candidate had appeared and had passed all the papers, but no notice was given to the candidate to explain or show cause against shortage of attendance. So the cancellation of examination by the board was held to be a quasi-judicial function, and principles of natural justice ought to have been followed. So writ of Chitra was allowed. Why? Because the Board of High School and Intermediate Education is a quasi-judicial body, and by cancellation of examination, they have passed a quasi-judicial order. And since no notice was given to Chitra to explain the shortage of attendance, so in the absence of show cause notice, the principle of natural justice was not followed. Hence, the writ of Chitra was allowed, and this writ was a writ of certiorari. Why it was allowed? Because no opportunity of hearing was given to Chitra as to why her attendance was short, why she was allowed to sit in the examination. She had passed all the papers and now you have cancelled his examination, cancelled her examination. This is bad. Hence, the order was quashed in a writ of certiorari. Then, second feature, dear students, with reference to certiorari is duty to act judicially. Whether the authority was acting or doing his act judicially or not. We have another leading case, very important one, A.K. Krapak versus Union of India. In this case, Supreme Court extended the principle of natural justice to administrative proceedings also. In this case, the facts were that for selection of J&K employees to Indian Forest Service, a selection board was constituted, consisting of, amongst others, the acting chief conservator of forest of the state, who himself was a candidate for selection, and he was finally selected for IFS also. His selection was quashed by the Supreme Court as the board could not have acted fairly and justly. Why? Because one of the members of the board was a candidate himself and therefore a judge in his own case. So the entire proceedings were vitiated by bias. I am a candidate for the post of IFS and I am member of the selection board also. So no one can be a judge in his own case. And I am a judge in my own case. I am a member of the board, selection board, and I am a candidate also. तो वही बात हो गई कि सैया भय कोतवाल तो अब डर काहे का. So Supreme Court quashed the appointment of A.K. Krapak because he was a member of the selection board and he was a candidate for the post of IFS. And not only this, he was finally selected as IFS by the same board of which he was a member. He was a judge in his own case. So the entire proceedings were quashed by the Supreme Court under writ of certiorari. Then we have on this point Maneka Gandhi's case also. The passport of Mrs. Maneka Gandhi was impounded by the government, by the Passport Authority under section 10(3)(c) of Passport Act 1967 in the interest of general public. But no reasons were given in the order. And one of the challenge was that section 10(3)(c) of Passport Act violated Article 14 and 21 relating to equality and life and liberty because it did not provide a right of hearing before impounding the passport. No notice was issued to Mrs. Maneka Gandhi. Supreme Court held that a provision of giving an opportunity to be heard to the person concerned should be read by implication in the Passport Act. Even if it is not mentioned in the Passport Act, even if it is not mentioned in section 10, that hearing should be given to the person whose passport is under consideration for cancellation or impounding. But the Passport Authority decided to impound her passport without giving any opportunity of hearing to Mrs. Maneka Gandhi. This order was deprecated by the Supreme Court and post-decisional hearing was given to the petitioner Maneka Gandhi. which ultimately satisfied the requirement of natural justice, that in the beginning, no opportunity of hearing was given to Maneka Gandhi, but at least later on, post-decisional hearing was given, which met the requirement of natural justice. So in all circumstances, this principle of natural justice, if not followed, then writ of certiorari will lie against the authority. Then feature number 3, dear students, is that certiorari is a discretionary relief. This writ can be issued to a judicial or quasi-judicial body on the following grounds. There are 3 grounds. Number 1, first ground is want or excess of jurisdiction. While deciding a case, you as a judicial officer had no jurisdiction. Suppose a divorce case is to be decided by family judge under Family Courts Act, and you have decided that divorce petition as civil judge junior division. So there was no jurisdiction with your court. So the order of divorce which you have granted is likely to be quashed in a writ of certiorari. Then B, violation of procedure or disregard of principles of natural justice if you have done. If you have not followed the principle of audi alter partem, you have not given right of hearing to the other party, or if you are biased in your decision, or if you have a personal interest in the matter, or your decision is not reasoned, no reasoning is given in the decision, still certiorari writ will apply against you. An order which is passed without hearing other party, an order in which the officer concerned is biased, an order in which the presiding officer of the court is personally interested, all these orders are liable to be quashed under writ of certiorari. And third ground is error of law apparent on the face of record. You have committed an error of law which is apparent in your order. The case of divorce maintenance should have been decided by the family court, but your order shows that you as civil judge junior division have decided a divorce petition. So you have committed an error which is apparent on the face of the record. So your decision passed against the law is liable to be quashed under writ of certiorari. Then, dear students, feature number 4 with reference to certiorari is that certiorari jurisdiction is supervisory and not appellate. High Court or Supreme Court is not hearing your appeal when you file a writ of certiorari. Although they have all the powers, even during exercising their supervisory jurisdiction, the courts have power, all those powers which they as appellate court have. But basically, their jurisdiction, while hearing a writ of certiorari, is supervisory. And consequence of supervisory jurisdiction is that court will not review the finding of facts. Yes, in appeal they can. While hearing an appeal, court can review the finding of facts reached by the inferior courts or tribunals, even if they are erroneous. See the beauty of law. See the beauty of writ of certiorari, that while exercising this supervisory and discretionary jurisdiction, the High Court or Supreme Court will not review the finding of fact, even if they are wrong, even if they are erroneous. So the function of certiorari is to quash the erroneous order and not to substitute a new order in its place. It is not the duty of the court to substitute a new order. The duty of the court, function of the court is, if they are hearing certiorari writ, if the order is erroneous, they might quash it. They cannot pass a new order in place of wrong order passed by the lower court or the tribunal. In nutshell, the certiorari writ will simply wipe out the order which is without jurisdiction and will leave the matter then and there as it is. They will not the High Court or Supreme Court, while exercising certiorari jurisdiction, will not pass a fresh order. They will just quash, they just wipe out the order passed by the lower court. So this is feature number 4. Then feature number 5 is that High Court orders not amenable to certiorari. See, the orders passed by the High Courts are not open to be corrected by certiorari. If you are not satisfied with the order of the High Court, then you can file an appeal or revision as the case may be. Thus, Supreme Court is not competent to issue a writ of certiorari under Article 32 against the order of the High Court, even in exercising the jurisdiction of writs or maybe of certiorari. So no certiorari order can be issued by the Supreme Court under Article 32 against the order of a High Court, because High Court is also a constitutional court. Then, dear students, feature number 6 is certiorari not for declaring an act or ordinance as invalid. This is not the job of the High Courts or Supreme Court that they will declare an act passed by the Parliament or ordinance issued by the President of India or the Governor of a state as void or invalid. No, they can do it while exercising other jurisdictions, but not while exercising jurisdiction of certiorari. Again, we have a leading case on this point, Prabodh Verma versus State of UP. It was held in this case that a writ in the nature of certiorari cannot be issued for declaring an act or ordinance as unconstitutional or void. Such a writ can only be issued to direct inferior courts to transmit their record for scrutiny and, if necessary, for quashing the same. But they cannot declare an act or ordinance as unconstitutional while exercising the powers of writ of certiorari. And feature number 7, dear students, is that no certiorari for Supreme Court or High Court. This writ can be issued only for the lower courts, subordinate courts, tribunals, or other authorities. A writ of certiorari can be issued by the High Court or Supreme Court for subordinate courts, but not to the High Court. High Court cannot issue writ of certiorari to another bench of the High Court, or even to its own benches, much less to Supreme Court or any of its benches. Supreme Court के लिए order कर देंगे High Court, very bad. It cannot be done. That High Court is issuing certiorari orders against the Supreme Court, and vice versa also. Supreme Court will never issue certiorari orders against the High Court also. So, dear students, this was in nutshell regarding the concept of the writ of certiorari.